Good afternoon, finally. Welcome, everyone. First of all, I'm very sorry about the streaming issue that we just had. I can assure you it wasn't me. I was here ready and waiting. Sorry about that, and thank you for rejoining, everyone. I appreciate that. So welcome to all of you, hopefully all of you. We had 630 registered this morning, so fingers crossed we've still got most of you on. Clearly, this is a popular topic. I am Lisa Nabou. I'm a healthcare solicitor, and I've been a solicitor for 21 years. I always get it in very early on these kind of training sessions that I've always defended healthcare professionals. So doctors, nurses, clinics, trusts, pharmaceutical companies, private hospitals, quite a broad range. Really. Deal with clinical negligence claims, a lot of birth injury, cauda equina and stroke cases, very sad matters, disciplinary before medical counsel and nursing and midwifery counsel. I also deal with inquests, and in addition to that, deal with complaints and investigations. And unfortunately, I've had to advise on criminal matters arising from healthcare treatment, such as alleged sexual assault and fraud, and prosecution for gross manslaughter. Now, I did a very short 6-month stint in Singapore, then went on to Hong Kong for 6 months, and that turned into 6.5 wonderful years in Hong Kong. I came back and decided that variety is the key to life generally, so I became a consultant. So it allowed me to do lots of different areas of work at different firms. And around that time, in 2019, I became a part-time judge. So in my judge role, I tend to deal with civil matters, so that's not criminal matters, and deal with a variety of personal injury, clinical negligence cases, you name it, very wide jurisdiction. I've also trained healthcare professionals for many years as part of the Bond Solon team until very recently when I've set up on my own. And I've trained on report writing for experts and cross-examination skills. And I'm also on the reserve list of the Solicitors Disciplinary Tribunal. So it's similar to the regulator for the GMC for healthcare professionals. And when I'm not doing all of that, I run a fitness company with my husband, who, for you rugby fans, he used to play for Fiji as a rugby player. So rugby is in our household. It's everywhere, and we love spending time with our 3 young sons and our new little baby daughter. So enough about me, on to the topics in hand. Brief introduction to BMA Law just on the slides there. For those who don't know, it's an independent law firm. It's to assist BMA members primarily, and you, as a major perk, get a discounted service if you're a BMA member, and all of the surpluses are reinvested back into the BMA. So on to the contents of what we are talking about today. It's about knowing your policy. That's really important, and understanding the different terminology. And we'll then move on to 6 main reasons for coverage problems. Rarely happens, but it is important that you know why they sometimes crop up. The impact of coverage problems for you personally and professionally, what to do if coverage problems arise, and more to the point, what not to do if coverage problems arise, and how I can help. We will be having some questions at the end. I've already got about 20 questions in the inbox. Unfortunately, I won't be able to get to all of the questions today, and any questions that are particular on a situation that you're facing at the moment with an insurer or medical defence organisation, I'm not able to comment on, because obviously I don't know the facts, so it wouldn't be appropriate for me to do that. And it's very much generic advice today, aimed at supporting and helping you navigate these issues. Now, knowing your policy. So you will be aware that there is a legal obligation on you when you practice medicine to have your insurance or indemnity, or a combination of both. That's a statutory obligation, and the GMC, Good Medical Practice, requires you, paragraph 101, to have your own cover. Now, when we talk about the cover, the requirement is for you to have appropriate cover and adequate, and that very much depends on the nature of your work and the extent of your risks. So what will be fine for you may not be fine for a friend who also practices medicine. So it's important to be aware that it's personalized to you. Now, when we talk about an insurance policy in this context, an insurance policy is a contractual document, like you take out home insurance. You're taking out insurance to cover you for professional negligence and professional, not just negligence, it's sometimes broader, but professional cover. And you are the insured and you pay a premium. Now, if you were to breach a condition and term of the policy, and it's an important term, then it would result in what we call a repudiation, which would in turn potentially mean that your insurance is null and void. Now, that is risky because it could potentially expose you to pay personally in the event of a successful claim for clinical negligence. So when we talk about insurance, that is what we refer to. When we talk about indemnity, this is often through the medical defence organisations, and it's a discretionary cover. There's not an insurance policy as such. There's a memorandum which sets out the nature and the purpose of that organisation. So each one will have their own memorandum. And there are articles of association, which are essentially the rules by which you as a member are required to A, know about, and B, follow. Okay, and within those rules, there is the discretion to suspend or end the membership. Both insurers and the medical defence organisations have, in my experience over the 21 years, provided exceptional and strong support to a variety of healthcare professionals. There is the odd occasion where things have cropped up, and this is what I'm talking about when I refer to the coverage problems, and that's often because of steps, or sometimes steps that have been taken, or sometimes steps that are not taken by the healthcare professional. But these coverage issues, just to reassure you all, are extremely rare in my experience. And your cover is, of course, the safety net in the event there is a problem, which hopefully there will not be. Moving on to the coverage problems now. We cannot cover or deal with today every eventuality. So I'm trying to group together the key areas that I've encountered for coverage problems. And the first one is material non-disclosure. So when you sign up and provide information, there is often an obligation on you to disclose the nature and extent of past, present, and potentially future civil matters or criminal matters that affect you as an individual and also professionally. Now, that is an extremely wide obligation, and it's required so that you give full and frank disclosure of everything that might affect the risks under the cover. Now, the problem is that sometimes there isn't this full disclosure. One large clinic that I assisted failed to disclose to their insurers a raft of complaints. And when they were asked, when they made a claim, and it transpired that in fact this had been the subject of a complaint a number of years ago, when they were asked why they didn't disclose the complaint, the point was taken that it wasn't a claim at that point. So it wasn't disclosed. But of course, when you look at this requirement in full and frank disclosure, it's to disclose any potential future complaints and claims. And if there is in fact already a complaint, then you are expected to disclose that. And remembering clinical negligence claims, the patient has 3 years to bring a claim from the date of the treatment or the date of the knowledge that the treatment was negligent. So there's quite a wide period. So there may be a complaint, it may then go dormant, nothing happens for a while, and then it becomes a claim. And the onus is on you to share that information if you know that there is this complaint. So transparency, and not concealing anything, either at the start of the cover or during the lifetime of the cover as well. So the obligation is to continue disclosing. Late notification. So again, just picking up on that point I said about the letter of notification. So some solicitors will send letters of notification. It's essentially a heads up that there might be what we call a letter of claim a little bit further down the line. And the letters of notification, if you receive them, will sometimes broadly indicate that you are the intended defendant, or these parties are likely to be involved, and the treatment during this period is likely to be under scrutiny. Now, some healthcare professionals, I've seen this time and time again, get spooked by receiving a letter like that. It is very distressing, and it causes upset and worry. And sometimes people will bury their heads. And they bury their heads and they think this might not go anywhere. It's a letter of a potential claim. It's not a claim. So they don't necessarily notify when they should. Sometimes it's accidental. Sometimes it's hoping that it goes away. And a particular point to mention are for those private doctors working in a private hospital. So the private hospital may receive a complaint. Now, the private hospital will not be responsible in law for your acts or omissions if you're in what we call an independent contractor. So in that situation, you could potentially become a defendant if a claim is brought. And the onus is on you, again, if you have your own cover, to be notifying that body. So that there's not what we call a late notification problem. So the hospital, the private hospital, is liaising with the patient or their solicitors, and then you come to your insurers or indemnity organisation too late after various steps have been taken. So if it concerns your treatment and there's criticism of your treatment, then the onus is on you to notify as soon as you possibly can. The next one is about prejudicial steps taken. So this is where steps are taken to refund, to offer credit to a patient. So an aesthetic clinic, for example, would offer refunds to patients, and they'd often suggest credit be given for future treatments. And one particular clinic asked for advice on drafting a settlement agreement to that effect. And my first question was, have you notified your insurers? And the response to that was, no, we're not notifying the insurers because we're paying for them privately and we don't want to pay the excess. To which my response was, the difficulty with all of that is that by taking these steps, you're likely to compromise your insurance cover in the event that the steps do not resolve the case there and then. So if it proceeds and the claim continues, and then you need your advice or you need some representation, if it's a court case, for example, or you're looking for advice on the cover on the legal costs, or you're looking for some further advice, then it's likely that those initial steps taken, the refund, the credit, the draft settlement agreement, the goodwill gestures, could be perceived to be prejudicial steps taken. And the difficulty is that it would potentially invalidate the whole insurance. So in the event that you're referred to the General Medical Council, then you may not have the protection of the cover and the legal representation that you would have had. And then you could be personally responsible again for all of the legal fees if you don't have that insurance and cover in place. In terms of dishonesty, the next one. So just briefly, it's dishonesty stroke conduct. So when I practiced in Hong Kong, it was a very, very sad case. I'm going to give you some practical examples. Most of them will be Hong Kong based. And a celebrity's baby died. And following the birth, the baby died. And there were various allegations about the delivery of the birth, whether too many pulls had been applied on the vacuum cup to bring the baby. out, and the obstetrician and gynecologist was referred to the equivalent of the General Medical Council. And in the course of that hearing, the nurse who assisted the delivery of the midwife, she was called to give evidence, and she accepted on the stand under cross-examination that she had deliberately tampered with her records, and that she had done that because she was fearful of her job, and she had essentially downplayed the number of the pulls. So essentially accepted she'd given dishonest evidence. Unfortunately for her, she was suspended from her role and referred to the equivalent of the Nursing and Midwifery Council, and her indemnity provider at the time withdrew the cover on the basis of the conduct and the admissions that she deliberately tampered with the evidence and the records. In addition to that, just on the conduct, I also advised, again in Hong Kong, a psychiatrist who had a sexual relationship with a patient. His defence before medical counsel was that she gave her consent, and unfortunately he was suspended for a lengthy period, and his indemnity was also withdrawn on the basis of his admissions. And then when he wanted to appeal the sanction, which is why he came to me, he obviously didn't have any cover for legal fees. So just to point out that the conduct and the dishonesty issues can sometimes play into the cover. Inaccurate information. So this, I would say, is where a lot of people fall foul. The good medical practice requires you to keep it all updated and to keep reviewing your indemnity and your insurance, and that is what is recommended generally. So you need to be providing accurate, truthful and complete information about things such as the scope of work, what you do, where you do it, what's the ratio of your work in terms of NHS and private, where do you work? So do you work in a clinic? Do you work in a hospital? And what's your income projection? So they are expected to be as accurate as they can be based on the work that you're doing now and your previous income. Now, again, when I was in Hong Kong, a doctor, an obstetrician and gynecologist was performing cosmetic breast surgery in his clinic in Kowloon, in a high-rise building, on a 21-year-old under local anaesthetic. And the indemnity provider initially questioned the cover. So if you are not being transparent and you're not fully declaring what you're doing, then you can expect some coverage issues. In terms of the last one on the slide, non-payment of your membership or your policy premium or late payments may sometimes feed in as well. So just flagging the impact. When indemnity and coverage or insurance is reserved, it's essentially pressing pause. So it's pressing pause on the cover, and it's alerting you to a potential investigation. For whatever reason, information will be provided to you and you'll be expected to respond. The stress of having your cover reserved or withdrawn is immense. So one client recently described to me that they felt devastated after 30 years of practicing. It led to so many sleepless nights and immense distress. They were given the opportunity to have indemnity reinstated. But it just goes to show that it has such a significant and profound impact that it is always best to be avoided. So in addition to a claim made against you, you could then have the added distress of coverage issues. And as I said at the start, these are extremely, extremely rare and are often the result of people not taking steps and sometimes taking steps when they should not have done. They need to act in accordance with their cover. Now, when the cover is withdrawn, that means it no longer applies, and that means that you could be personally exposed on the claim, if it's a claim. And the risks of that are quite wide, because it could mean that you're personally responsible for paying not only the damages, which is the compensation to the patient if the claim's successful, it could mean that you're personally responsible for the claimant solicitor's fees, and also your own fees should you choose to be represented. Now, those fees and amounts can soon add up, and it's the uncertainty and the worry. In addition to that, you have potential risks with practicing privileges, depending on the arrangements. And if you have your insurance withdrawn, it can obviously affect your reputation. And there are potential risks to personal assets. Now, I just mentioned this. It doesn't happen very often at all, but there is this very rare possibility of it happening, and it's important to be aware of it. And the amount of clients over the years where it has happened, and they say, I didn't even think about any of this before it happened. So today's talk is going to hopefully just make you focus on what to look out for and how to avoid all of this, because that's the goal, to make sure that you're not in this situation. Now, in terms of the last case about making sure you're not in that situation, I did advise a different plastic surgery company, and they had insurance for their independent contractors also on that particular policy, but because there'd been a late notification, and also material steps were taken to try to do a deal with the patient, unfortunately for them, they didn't have the insurance. So that particular case was eyelid surgery, and it led to psychiatric distress by way of adjustment disorder, and loss of earnings and the cost of remedial surgery. And all of that, unfortunately, then fell to the clinic to pay. In the absence of their insurance policy, they didn't have their cover in place. So moving on to the next slide, what to do when there are coverage problems. So avoid these beforehand. Read, understand, check and comply. Knowledge is key. If you're not sure whether you're covered, check. And check before you carry out the treatment. The onus is on you to keep updating. So if and when you take on a new hospital or a new area of work, then the obligation is very much firmly on you to go and disclose that before you carry it out. If you, when cover is reserved, if you're not sure why, now it should have been explained to you, but sometimes it's explained in a variety of different emails from different people within the company. If you're not sure what is being put forward, then it's really, really, really important that you actually check. So it's just a fundamental point to really check. And if you don't understand, then ask for written confirmation of the details. What are the alleged periods that something's been suggested? When is it in terms of, say, audit, income projections? When is it being suggested that you've not properly provided the information? And ask for information. If you haven't got your renewal forms, for example, to hand, then you can always ask for them, and very much work with your MGO and your insurer to properly understand the issues. So once you've gathered all of the facts, then you'll be able to just take a step back and reflect. Check the internal guidance, as well as any potential appeals or complaints policy that the organisation might have, and ask, like I said before, for all of the documents that are relevant, including any meeting notes or the like. and know your deadlines. So if a deadline has been imposed on you to respond for further review, then make sure that you know what the deadline is, and make sure, very importantly, that you meet that deadline and comply with the timeline. What not to do. Again, this is over the years, summarising some of the things that have gone wrong when there have been coverage disputes. If I said to a doctor, don't panic, it's pointless, because, of course, it's a bit like an epidural. Just as you're about to welcome your baby and the doctor says, stay nice and calm. No one stays nice and calm in that situation. And trust me, if your cover is reserved or withdrawn, you will not be calm. Okay, but it is important, if there is a coverage issue, that you do not take any prejudicial steps. Okay, what do we mean by prejudicial steps? Well, we mean don't go off to the claimant and offer them a deal. So don't offer a reduced offer of settlement to try to get rid of the matter. Remember, particularly if it's being reserved and the final decision hasn't been taken, then the obligation on you is not to take any prejudicial steps at all. Unfortunately, I've seen people over the years panic and go off and do, quite frankly, silly things where they make these they have these knee-jerk responses, and they go in and they try to fix a problem, but then make the problem a lot worse. So just be really mindful, and remember, you have a statutory legal obligation, and it's clearly on you in the GMC good medical practice as well. Your obligation is to be indemnified and insured, and you need to be very careful what you say to the claimant or the claimant solicitor in the event that your insurance or indemnity provider coverage is under review. So be careful and don't say anything that then could come back to prejudice you further down the line. So what you don't want to say is, I have no insurance or indemnity, and then you're referred straight away to medical counsel, when in fact you did have it, and there are issues that are being investigated or that you're seeking a review of. So just be very, very wary of that. So in terms of how I can help, I can help and support you if there are some issues. I have assisted very recently, actually, a BMA member on an indemnity review. Fortunately, that was successful. That case and all of the other cases when we review require a detailed review of the actual policy, the insurance policy, or the articles of association, and also in terms of renewal forms that need copies such as that. And then we would be able to draft reviews or appeals with supporting bundles, but help you understand what the merits of review are. So if you've taken the prejudicial steps and you've essentially scuppered the position from a coverage perspective, you will get some advice from us on the merits of whether to proceed with the review. So it's really to help you understand what the scope of indemnity is, and to clarify, so to help you clarify that, and to help you work with your provider to check if it is reinstated, whether it's retrospective, current, or future, or all of the above. And remember again that such challenges and such coverage problems are extremely rare. Okay, now I feel like I've galloped through that, but it does give us a bit of time for questions. Those are my details on the screen, and you will be sent the details afterwards. Feel free to contact me in the event I can't get to your question, but please remember that I won't be able to give any advice on any specific circumstances. So let's kick off with... Okay, so question is, NHS employed doctors are usually covered by Crown indemnity. What doesn't this cover? Okay, so the NHS clinical negligence schemes cover claims for clinical negligence. It wouldn't cover you for GMC proceedings, criminal investigations, or disciplinary hearings. I hope that clarifies that one. Someone else, what are the risks of practicing without indemnity? Well, the risks are you lose your license, which is probably the most draconian and significant risk that you can face. Let me have a look at some other ones. Vicarious liability, where can I get a quote? You'll have to shop around. There are so many options out there, and I'm not able today to promote or point you in the right direction there, I'm afraid. Yeah, some of these questions are very specific, and I'm not able to address some of these. Should we notify our medical defence organisation of every solicitor's letter of notification? We do receive a number of these at GP practice level, but following release of records linked with this, very rarely receive any follow-up. The answer is yes. So full and frank disclosure, early notification, I would say yes. Otherwise, if it's a letter of notification that turns into a claim and you haven't notified, then there's the potential late notification problem, and you don't want that. In what circumstances will cover be denied? I've already talked you through the main ones, but the failing to disclose the full scope of work and income projections and the place where you carry out the work and also material non-disclosure and late notification, I would say, are probably the key. Yeah, I have indemnity with NHS. Should we obtain indemnity with defence organisations? So that was linked to an answer to a question. So obviously you have the NHS claims cover and the recommendation, the BMA site recommends and the GMC and obviously other sites as well recommend separate cover. Controversial. Why is insurance language always vague, and why doesn't it inspire confidence? I can't really comment on that particularly, but I'll tell you a story. My home contents insurance policy said that if you leave windows unlocked when you go on holiday, it could invalidate the policy. So every single holiday, my husband, who is Fijian, and anyone who knows Fijians are operating on Fiji time, he is still packing as the taxi pulls up the drive, literally. And I've packed 3 weeks before, and I'm running around the house, locking every single window. And I always say the next holiday will be different, but it's not. I'm always locking every single window because it said it could invalidate. So it's putting you on notice that there's a risk there. So I'm not sure if that helps or answers the question, but window locking is definitely something that happens before every holiday. Can I help explain the difference between discretionary cover and insurance cover in simpler terms? Discretionary cover is as it suggests. So, most of the time, discretion is used and covers members. There is the odd occasion, as I've pointed out, that it is not covered for the reasons that I've explained. Contractual cover is as part and parcel of an insurance policy, but again, there are some exceptions when cover is not in place under an insurance policy. So insurance cover is contractual. There's a contract there between you. think I've probably covered most of the key questions that I can. I'm scrolling to try to check. Bear with me. For someone who has had their indemnity revoked due to a GMC hearing and suspension over 10 years ago, and then had reapplications over subsequent years refused by certain organisations, what would you suggest? You can cast the net wider, obviously, and shop around. There are lots of different providers. You could potentially seek a review of the refusal of the two organisations that you mentioned. That's what I would probably suggest to that one. And someone has asked, in terms of private practice at a private hospital. So private doctors, the general expectation is when you practice at a private hospital, the expectation is that you take out your own insurance or indemnity. It is really, really important when you join a private organisation that you check what is the position in terms of cover, what the limit of the cover is, and importantly, what it covers you for. So if the private hospital doesn't cover you at all, then it's clear you need your own. And then if you get your own, you need to be clear in your own mind what it's covering you for whilst you're working at the private hospital. But in essence, don't assume anything. Always check. And if you're not clear on what the scope of the cover is for you, then the onus is on you to check beforehand. Okay. There is sometimes a situation where smaller private clinics will bring the independent contractor in on their own policy. I've seen that. And again, you need to be clear as you join, what is it that you're being covered for. And that comes back to the first slide. It's about knowing your policy and scope of cover. And not assuming anything. UK indemnity, does it cover overseas work? Not generally, unless you've organised that to be on your cover. So no, you should never assume that it covers any overseas work. In fact, let me give you an example. When I was in Hong Kong, a fertility clinic sought my advice on whether their insurance policy covered them for sex selection treatment. And I said, it's illegal. So no, it doesn't cover you for sex selection treatment. And they said, if we go overseas and we carry this out overseas, or we facilitate referrals to Bangkok clinics or other clinics, can we have the cover? To which my answer was no. But no, it's kind of linked to the overseas work. But no, you should never assume that if you're doing short stints to Dubai or to other places, or you're acting as a medical legal expert, for example, you should never assume that your indemnity here covers you for that work. And the onus again is A, declare it, and B, check that it's covered. Okay. Yeah, just looking at the questions there, they're all quite specific to companies, so I'm not going to try to tackle those for the reasons that I've already said. I will be responding to the ones that I feel are appropriate. So unless anyone has any more questions, I've managed to gallop through this talk in good time, even with the technical issue. Just checking no more questions coming in. No. Okay, well, that probably concludes today's talk, and I finished early, which is extremely unusual. What are the time limits for a claim? Oh, I can answer that. That's 3 years from the date of treatment, or 3 years from the date that the patient knew the treatment was negligent. Okay, so in essence, it's 3 years, but it could be longer than 3 years. The exception to that is obviously a child and someone that lacks capacity. So with a child, the limitation only starts to run from age 18, so they have until 21 to bring a claim. So if you're treating children, obviously that's much longer than 3 years. Do doctors have any kind of indemnity in specific locations, like on a plane? So I think in probably a Good Samaritan kind of act there, you'd have to check your policy and what it covers. So different organisations cover different. So never assume that it covers you. Check the policy. Please do take away this today. No assumptions. Check. And avoid the situation where you're left with a coverage dispute, which, as again, stress again, that are incredibly rare. Okay, thank you everyone for your time. Very much enjoy presenting this, and I'll get back to those questions that I can and I feel are appropriate. I'll get back to you on email. Thank you all for joining. Thank you. Goodbye.